Karen J. Bibisada from Bachelor of Secondary Education, major in English. And my topic are the Republic Act 8293, or what we call the Protecting the Intellectual Property in the Philippines, the Law of Copyright, Copyright versus Plagiarism, and also the Avoiding Plagiarism. So in the introduction, in the subject technology for teaching and learning is the best way to learn from technologies in teaching. Now, we are just focusing to the topic, the Republic Act of 8293, which is the act protecting the intellectual property in the Philippines. So, these are my topic, the law of copyright, copyright versus the plagiarism, and also the avoiding plagiarism. The Republic Act 8293, or the Protecting the Intellectual Property in the Philippines. So when we say the Republic Act 8293, IP is what we call the intellectual property, which is refers to the creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. So what is Republic Act number 8293, or the Intellectual Property Code of the Philippines? So it shall protect and secure the inclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such periods as provided in the Act. The use of intellectual property bears social functions. So, the Intellectual Property Office of the Philippines, or what we call the PHL, was created by virtue of the Republic Act number 8293, or what we call the Intellectual Property Code of the Philippines, which was signed into law on June 6, 1987, and took effect on January 1, 1998. So let us proceed to the law of copyright. So what is copyright? Copyright is a collection of all rights enjoyed by the owner of an artistic or literary work. Copyright, or what we call the letter C, is a legal means for protecting an author's work. It is a type of intellectual property that provides exclusive publication, distribution, and usage rights for the author. This means whatever content the author created cannot be used or published by anyone else without the consent of the author. There are three basic requirements for copyright protections. That which is to be protected must be a work of authorship, it must be original, and it must be fixed in a tangible medium of expressions. That is according to the Copyright Gov of 2020. So what constitutes copyrights and fragment in the Philippines? So under Philippine law, copyright infringement occurs when there is a violation of any of the exclusive economic or moral rights granted to the copyright owner. So it is also consist in aiding or abetting such infringement. Let us go to the plagiarism versus copyright. So when we say copyright infringement, or copyright and plagiarism are related but distinctly different in situations. So when we say copyright, it does not protect ideas. So it only protects the fixed expression of those ideas. A person infringe on copyright when he or she copies this or distributes, displays, and etc. the work in a manner that is in violation of copyright law. Copyright infringement is a legal matter. Plagiarism, on the other hand, is when someone passes off the work of someone else as one's own or without acknowledgement of the original source. Plagiarism is avoidable by making sure you always give credit to the original source when using the ideas or works of someone else in your own work. This is an ethical situation that is addressed by university policy and may have negative repercussion if violated, but it is not a legal matter. For example, in scenario 1, which is in plagiarism without copyright violation, if you copy the words to one of Shakespeare's sonnets and put your own name to it, and then post this to a website, you would be guilty of plagiarism but not copyright infringement. Since Shakespeare's work are in the public domain, you have no reason not to copy and use them at your discretion. However, by passing the work off as your work, you have plagiarized Shakespeare. To avoid the charge of plagiarism, be sure to correctly cite and credit the source of any information you borrow from others. In scenario 2, which is in copyright violation but not a plagiarism. So if you copy the lyrics to a recent top 40 song and post it to a website with credit given to the singer or artist who recorded the song, you will be guilty of copyright infringement, but not plagiarism. Since you have credited the original source, you are not claiming the ideas as your own. However, since you are distributing copyrighted material without the copyright owner's permission, you are infringing on their copyright. Scenario 3, which is in both copyright violation and also plagiarism. So if you copy the lyrics to a recent top 40 song and post it to a website claiming it as your own work, you have violated the copyright on the work and you have also plagiarized the songwriter. Let us go to the avoiding plagiarism. So what is plagiarism first? Plagiarism is the use of someone else's ideas or language without acknowledging that we did not create them. This definition applies to ideas, words, and unusual structures regardless of where we find them in a book, on a web page, or in an email. Whenever we include another person's information or wording in a document, we must acknowledge the source and include a citation that will tell your readers where obtained it. Otherwise, we are guilty of plagiarism. So when we say plagiarism, it is sometimes seen as intellectual theft. Plagiarism. So how can we avoid plagiarism? So the best way to avoid plagiarism is to understand what it is. Then we must avoid committing either accidental or intentional plagiarism. Before defining plagiarism, however, we define three other terms, which is the quotation, paraphrase, and also the summary. Here is an example of quotation. A quotation must use the exact word of the source or ellipsis if we omit any. If the quotation is relatively short, for example, fewer than 3 lines or 40 words, those words must be enclosed in quotation marks. For instance, this is an example. As Stephen Strange points out, contrary, we put some quotation marks, contrary to some popular notions, writers do not have full-blown ideas popping out of their heads like Athena. And we put the close and open parentheses and the page where we read the saying. Notice that the quotation is introduced as Stephen Strang's out. So Stephen is the author. The exact words are enclosed in quotation marks and the page number appears here using the MLA style. The end of the paper would include a bibliography entry giving the author, the title of the source, the publisher, date of publication, and etc. Paraphrase. To paraphrase is to put the ideas in a passage into our own words, usually following the order of the ideas in the original. All major ideas are included. A paraphrase is often shorter than the original. So a paraphrase that defines terms or concept might actually be longer. Any paraphrase requires the same kind of citation as an exact quotation. So in summary, a summary puts the major idea or ideas of a passage into our own words and significantly shortens it. Once again, we must attribute the ideas to the original source.